When we're speaking about natural law in science, we're speaking about the laws of thermodynamics or planetary motion, electromagnetism, gravity, strong force, weak force, the laws of physics, the chemical properties. But are there natural laws inherent in things like morality? Is there a standard? Is there a law that governs all of us? So when we speak of things like rape or torture, corruption, thievery, murder, do we all agree that there is a moral law, a natural law at the moral level that applies to all of us? I'll take murder, for example. The definition of murder would be the unjustified killing of another human being. And I think we would all agree, every single one of us, that the unjustified killing of another human being is wrong. Now, where we differ is in the definitions. What is justified and what is a human being? And if you look at things throughout history, that's where we differ. Not on the standard that the unjustified killing of another human being is wrong, but on the definitions. So, for instance, if I kill in self-defense, I'm justified because there was a reasonable apprehension of fear for my life in which I acted out. Just war theory, right? We can go to war and kill others because we are justified under a theory of just war. There's different types of mitigation circumstances, etc. On the other hand, the human being argument. Hitler and the Nazis felt that they could kill Jews and gypsies because why? They weren't human beings. They were pigs and dogs. Pigs and monkeys, sorry. But the reality of it is that we all agree that the unjustified killing of another human being is wrong. We just get caught up in the justification, in the rationalization of that definition of murder. I want to give you an example, and really you can understand how difficult this can be at the definitional level. I'm going to start with Roe v. Wade. This is U.S. constitutional law, 1973. And of course, Roe v. Wade was where the U.S. Supreme Court said that abortion is a legal procedure in the United States of America. Okay? Now, what I want to do here is I want to read really quickly from the actual case, okay? And in the actual case, I read, the Constitution does not explicitly mention any right of privacy. But in a line of decisions, we've recognized that a right of personal privacy exists under the Constitution. And then they basically go on to say that this right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the 9th Amendment's reservation of rights to the people, it's broad enough to encompass a woman's decision whether or not to terminate her pregnancy. So basically they said under the U.S. Constitution, there's this right of privacy that is the justification for killing human life, right? There is a higher justification. I'll read on. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable, even in early pregnancy, may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There's also the distress for all concerned associated with the unwanted child, a problem of bringing a child into a family already unable, psychologically or otherwise, to care for it. And it goes on talking about the stigma of an unwed mother, etc. Again, my point is that there's a justification that is higher than human life in this case. Okay? Now, if you go on, you can find very quickly that in the Partial Birth Abortion Act that was just upheld in 2007, that at some level, the justification doesn't work anymore. So when you read partial birth abortion, which is at a very late stage in pregnancy, we read, a moral, medical, and ethical consensus exists that the practice of performing a partial birth abortion, an abortion in which a physician delivers an unborn child's body until only the head remains inside the womb, punctures the back of the child's skull with a sharp instrument, and sucks the child's brains out before completing delivery of the dead infant, is a gruesome and inhumane procedure that is never medically necessary and should be prohibited. Again, you can see what we're doing here. Under U.S. constitutional law, we're saying the justification only goes so far. At one point, the unjustified killing of another human being is wrong. The justification does not hold up. Understood. Let's take this now to federal criminal law. I just told you constitutional law. Now I'm going to go to criminal law. Do you remember Lacey and Connor Peterson? You remember the woman, Lacey Peterson, who was killed, and she was carrying a child, Connor. And in connection with that case, she actually was killed. Her fetus was killed. And Scott Peterson was tried and convicted of double homicide. And in connection with that case, there was the Unborn Victims of Violence Act, which is also known as the Lacey and Connors Law, which basically says that if you kill someone who is carrying a child and you are otherwise guilty of homicide, murder as defined under the law, you are guilty of double homicide. It doesn't even matter if you knew that this woman was carrying a child. You are convicted of double homicide under federal criminal law. Now, do you see the interesting disconnect there? Under U.S. constitutional law, we said, hey, there might be a medical procedure where we can abort a fetus, but under federal criminal law, we are going to give this fetus the protection of under the law. Very interesting. Now I'm going to take you on to civil law. This would be where we can, in the different states, we have civil standards of law. So in this case, let's say that I am driving recklessly in Chicago, Illinois. I crash, I kill a woman who is pregnant. I can be sued for double wrongful death under Illinois law. Under Illinois law, they actually protect the unborn fetus, in this case, the Wrongful Death Act of 1980 in Illinois. The state of gestation or development of a human being when an injury is caused, when an injury takes effect, or at death shall not foreclose maintenance of any cause of action under the law of this state arising from the death of a human being caused by wrongful act, neglect, or default. Do you understand what they're saying there? They're saying, we see value in this human life, so you can sue the surviving family for double wrongful death. You can sue and say that not only did the woman die, but she was carrying a child. We can sue for double wrongful death. What's my point in this whole exercise? My point in this whole exercise is that we all agree on the universal standard, the natural law standard, that the unjustified killing of another human being is wrong. Where we disagree sometimes is at the definitional level of what is justification and what is human life. The reason I use these cases under constitutional law, criminal law, and civil law is to show you that not everybody has this figured out. There's a lot of tension here, especially in the case of the personhood, the rights of a human being that is being carried in utero, right? A fetus, a baby. And so if they haven't figured it out across all these different lines of law in the United States, you can see that regardless of my moral religious standpoint on the case of abortion, you can see that it's a slippery slope when you start to try and justify around under different areas of law that the unjustified killing of another human being is wrong.